Welcome to another edition of the Legal River Podcast, a weekly look at the laws and legal issues facing small to medium-sized businesses.
Hi, I'm Cliff Hyra, and the name of my firm is Hyra IP. Today will be the second part of my two-part series on the steps for getting a patent. Today we'll be covering the last two steps, Step 3, preparing and filing your patent application, and Step 4, getting your application through the examination process at the United States Patent and Trademark Office. Step 3 is the actual preparation and filing of the application. And once you've made your decision, you can move forward. What you want to do is, in the application, is describe your invention sufficiently that somebody could make and use your invention based on the description that you've provided. You want to provide figures, drawings showing your invention, and some background information if it would be helpful to an examiner, to someone reading the application to understand what your invention is. If you're filing a provisional application, you do not have to put in the application any claims, and you can use kind of sketches, hand-drawn figures as the drawings. However, if you're filing a full non-provisional application, you do have to file what are called a set of claims. And that's where you lay out exactly what you're seeking protection for, exactly what is new and different from what anyone else has done before. It's a very exact legal instrument, and so I strongly discourage you from attempting to draft your claims yourself. Hopefully you already have or are able to find a good patent attorney to work with, and that makes the process easy for you. You basically take all the information that you have about the invention, turn it over to the attorney, they'll put it in the proper format, turn it into a full application. And then your job is to review the draft that they provide you, answer any questions or respond to any comments that they have, add any additional information that's really you feel is necessary, or make any changes that are appropriate. And then your attorney will file that application with the United States Patent and Trademark Office. So at that point, you can mark patent pending on your product. And if you want a little more information about patent applications, you can visit the United States Patent and Trademark website at uspto.gov. And once you have that application filed, then it's time really to begin your business. You can't wait until the patent is issued. Just having that patent pending is going to discourage other people from copying your invention. So the fourth step is the actual examination and prosecution of that application that you just filed, and getting it through the office to the point that it's granted. So the first part of that is waiting. When you file your application, it has to get in line behind all the other applications that are pending, waiting for an examiner to review them, and there are hundreds of thousands of them. By the time you get your application filed, there might be 1 million or more. So as you might imagine, there's a number of patent examiners that are responsible for examining these applications, 5,000, 6,000, but even so, it takes quite a long time to work their way through that queue, and you're looking at probably a 2-year wait before anyone even takes a look at your application. But that's the main reason why you don't want to wait. You can't wait 2 years to start your business. You got to get that going in the interim while the application is pending. But after those 2 years, an examiner will pick up your application and review it, decide whether it follows the law, and they'll perform their own search using the patent examiner patent database to determine whether someone else has already done what you're claiming is your invention, or whether your invention is obvious. And the examiner will then send an official report called an office action. And the examiners are really discouraged. There's a lot of pressure on them not to allow any bad patents. There's been a lot of media publicity about bad patents lately. So almost always, initially, the examiner will reject your application and give some explanation for why your invention is not new. So then what you have to do is respond to that, follow a response explaining how your invention is different from whatever it is that the examiner came up with. It's kind of your job to prove, to show why your patent should be granted. And sometimes this takes quite a while. It can take, usually it takes about a year, can take longer than that, can take several years. And once you finally convince the examiner, his supervisor, your application will be allowed. If you pay the fees, your patent will be granted, you'll be given a patent number, and at that point you can list the patent number on your product and know that you're protected from competitors in the way that I mentioned earlier. So if you have an invention, you're looking to protect it with a patent, the 4 big steps are patent search and opinion first. Second, pick what type of application you want to file. Third, prepare and file your application. And fourth, to prosecute that application, to respond to the examiner's objections, talk to the examiner, and convince the examiner that your patent should be granted. Thank you for watching. This concludes our 2-part podcast on the steps for getting a patent. I'm Cliff Hyra. The name of my firm is Hyra IP. And if you have any questions, you can reach me at the contact information provided on my website, hyraip.com, or you can contact Legal River at podcasts@legalriver.com. Thanks again.
Thanks for listening to this edition of the Legal River Podcast. If you have a business law question you would like to see answered in a podcast, please email us at podcast@legalriver.com. To reiterate, all views expressed in this presentation are intended only as a general discussion of the issues and should not be regarded as legal advice. For additional details or advice about a specific situation, please consult legal counsel directly.